sending down a ripple effect.
Okay, welcome back. I think it's time to move on. And the next session, it's called Protection in Europe, the Common European Asylum System for the Future. And to chair the next session, we have Cecilia Bailliet. She is a professor at the Department of Public and International Law at the University of Oslo. Okay, thank you.
Thank you very much. In this section, we are moving towards trying to identify what types of solutions may be coming from the European level. And the overview of the topics in this panel actually are a little cautious. So it will be interesting to see to what extent they feel original solutions will be coming from the regional level, or maybe we have to think a little bit harder at the national level. The first paper will be by Jens Vedsted-Hansen, who is a professor of law at the University of Aarhus in Denmark. And he will be followed by Vigdis Vevstad, who is a researcher at Fafo and chair of the board of the NIM. And she's also a guest researcher at the Norwegian Center for Human Rights. And finally, she will be followed by Erna Blöndal, who's the managing director of the Nordic Institute for Migration and Refugee Policy. I warmly welcome Jens to take the floor.
Thank you very much, Cecilia, and thanks to the organizers for inviting me here. You suggested that we were going to talk about solutions, and that may be overselling my message. I'm not quite sure there'll be solutions in what I'm going to say. I sometimes wonder if there have been true believers in the common European asylum system. I don't know if such a person might be around here, but such possible true believers may sometimes have a sense or a sentiment which can be compared to that of a Stalinist in Eastern Berlin on the 10th of November 1989. I mean, is it all collapsing? That's the problem. And of course, I'm not supposed to have many proposals on this because I come from a country which is by definition agnostic or atheistic, or at least doesn't participate in anything, or not very much at least. On the other hand, I'll try to take the role as the neutral observer and identify a few things. As you can see from the presentation of the conference, I'm going to focus on three different issues which could be arguably be considered as the main dimensions of the responses by the EU and its member states to the asylum crisis. I know terminology can be debatable here. I use the term asylum crisis or protection crisis. The first one is the external dimension, including the much focused EU-Turkey arrangements and other external measures. The second one being the attempts to relocate asylum seekers within the EU. And the third dimension is the intensified harmonization of legal standards. Before going into these three dimensions, I'll just sort of recapitalize a little bit what could be seen as the main developments posing the challenges to the common European asylum system. They are fairly obvious and well known, of course. I think they could be summarized like, first of all, an increased strain on the asylum systems in certain member states, which is, of course, not unrelated to the responsibility criteria of the Dublin regulation. Second, the collapse of that very Dublin system, or at least what some people would claim to be or allege to be the collapse. First of all, because there was deficient asylum systems in certain member states, so Dublin transfers were essentially suspended. After that, it also ended up in having the very operational basis of the Dublin system becoming dysfunctional. That was Eurodac, which simply didn't work anymore because registration and fingerprinting of asylum seekers became more or less absent, I think, in particular in Greece. And of course, the very fact that Dublin became suspended introduced a very odd structure of incentives in the whole system. For asylum seekers, it was all about moving onwards from Greece, because they were sure since the MSS judgment in January 2011 that they would not be returned to Greece for the time being. So it was a strong incentive towards secondary movements. And for Greece, it was perhaps also a kind of incentive not to remedy its asylum system, because they could just get rid of people and then being sure not to have them returned. I don't say that this was the strategy, but on the other hand, incentives can sometimes be for real. Finally then, when it all went wrong during the summer of 2015, there were also some member states, in particular of course Germany, due to Chancellor Merkel, which actually refrained from insisting on Dublin returns. It is somewhat ironical that, if I remember well, the first beneficiary of her position, amended position as it were, was actually Hungary, to which she decided not to return Dublin returnees or to carry out Dublin transfers. So, talking first about the external dimension of the EU asylum policy, I think that parts of the developments which sort of resulted in the so-called crisis, which is a crisis indeed, of course the root causes were events in the neighborhood of the EU, but then also there were some external control mechanisms that somehow seemed to not work as efficiently as they were supposed to do. We have seen rejections and pushbacks at certain external borders also during the crisis. Indeed we have. On the other hand, there were two sort of normative and practical mechanisms that became modified. First of all, I think the extraterritorial pushbacks in the Mediterranean, I don't mean to say they didn't function. I think they have been functioning all the way through, but they become somehow modified by the rescue operations. I think the tragic boat accidents off the Italian coast in October 2013 probably sort of sparked this development, which resulted in the Mare Nostrum operation, then later taken over by the Frontex-led Triton operation. But all, to various extent though, all of this implied that to some extent pushbacks and mere interception became modified by rescue operations. Secondly, at the time there was not yet a very strong or clear policy on returns to safe third countries. I'm afraid that in hindsight we must realize that it was all in the shaping by then. But for a long time, a number of neighboring countries were not in practice considered as safe third countries. That all changed, and we saw increased tendencies toward closing of the external EU borders, all of course aiming at restricting access to asylum. We have seen various features of this. The more sort of visible ones, of course, being the fences raised, not least by Hungary, which have, I think, both symbolic and very real effects on the possibility to access asylum, and which seems to be ever expanding also in territorial scope, actually. Secondly, we have seen the increasing definition of safe third countries and the increasing prevention of arrivals of asylum seekers. I'm going to elaborate a bit on the last two tendencies. First, non-arrival. Still, we have search and rescue operations, and I think Italy is still playing a quite heroic role in this regard. Wasn't it close to 1,000, if not 1,400 persons rescued yesterday or 2 days ago? But we have seen again modifications of the search and rescue strategy. We have the EU NAVFOR Operation Sophia, which was first just pushing back, but due to some leaked information in the late winter, it might seem that it was going to be an even more sort of forceful operation, which would eventually also include almost invasion in northern Africa. Then we have the Khartoum process, as I think it's named, the hub of partnerships with third countries in Africa. And thirdly, we have the EU-Turkey agreement. I use the inverted commas here because in official EU documents, the term agreement is not used. I think the official rhetoric is that it's a statement, which is quite funny for many reasons, I think. But of course, it has some roots and implications for the applicability of EU law here. These are all reinforcing non-arrival policies in various manners. And I think it's important to see the EU-Turkey agreement as primarily a non-arrival mechanism. It is also a way of reinforcing the safe third country policies because the Commission, during the preparations of this agreement statement of 18th of March, decided that Turkey could be considered a safe third country. But it is not very many people who are physically being returned or due to the inadmissibility of their asylum applications in Greece for safe third country reasons. And there has been a kind of problem, you could say, with the Greek asylum appeals committees, which did not really generally consider EU to be a safe third country. Then the composition of these asylum appeals committees were changed, and I'm sure that there was a kind of connection between their position towards the safe third country notion and the change composition. And we still have to see what effect this change of composition will have. And of course, we have other safe third country policies evolving. According to rumors, Bulgaria and Turkey either are preparing or have concluded a similar bilateral agreement, which is inspired by the EU agreement with Turkey. As far as I understand, it is not yet, at least not operational, and maybe not even formally concluded. If anybody has information, I would be happy to receive it, actually. But we don't have to look far away to learn of new safe third country policies. I don't want to mention my wonderful host country here, but I think that you know what I'm alluding to. Isn't Russia now a safe third country? These policies are, of course, whether non-arrival or safe third country policies, are certainly problematic from both legal and other perspectives, because they may result in at least indirect refoulement. They could also, to some extent, be seen as resulting in direct refoulement, and in any event, they are circumventing refugee convention obligations. The difference, importantly, is that it is possible to initiate legal challenges at domestic and eventually at European level against the safe third country decisions or policies, because they result in inadmissibility decisions, which can then be tested against both the European Human Rights Convention and Article 38 of the EU Asylum Procedures Directive. The difference here is then that non-arrival policies, due to lack of visibility, lack of formal legal status of activities, are much more difficult to challenge in legal terms. We may pursue that in our discussion. The second dimension of the EU responses in my structure here is the attempt to relocate asylum seekers within the EU. You may know that, you certainly know that there have been these decisions during 2015. First, a voluntary scheme of relocating 40,000 asylum seekers from Greece and Italy. Secondly, an additional 120,000 under a mandatory scheme to be relocated from Greece, Italy, and Hungary. And again, ironically, Hungary is one of the two member states now challenging this very decision in the EU Court of Justice. Regardless of the legal sustainability, it is fair to say that it is not being implemented in anything close to an efficient manner. I have an outline of the proposed recipient countries here, where you can see a strong a strong division or differentiation of responsibilities, but in practice this doesn't happen at all. I found a recent Commission document, less than a month old now, which shows that among the total of 63,000 decided relocations from Greece, only 4,455 have at the end of September taken place, and the pattern is similar for the relocations from Italy. Meanwhile, apparently Dublin transfers have been sort of not starting because they were never really suspended, but they have been sort of reinforced towards Italy. And the Commission is preparing for opening also for Dublin transfers to Greece. I'm not quite sure how realistic that ever will be. This all, of course, relates to the Dublin regulation, and I will not pursue this further because we have agreed that Vigdis is going to talk a bit about the proposed recast Dublin regulation, where there will be a kind of corrective mechanism. Maybe some would say, skepticists would say that the experience is not very promising as to these relocation schemes anyway. The third track of the EU responses is the attempt to intensify harmonization of legal standards. That actually dates back more or less to a period in a point in time previous to the sort of perceived crisis. And it is a kind of implementation of the Commission President Juncker's policy guidelines. That then the Commission issued this communication on the so-called European Agenda on Migration already mid-May last year. That was then followed up by a communication on reform of the common European asylum system and legal avenues for immigration in April this year, which sort of laid the building blocks for how to revise the instruments of the common European asylum system. So far we have seen two reform packages, one concerning the Dublin system overall, including the Dublin regulation and Eurodac, and also including the transformation of the European Asylum Support Office into a European Asylum Agency. Again, I'll refer to Vigdis on the Dublin stuff here. More recently, we have seen a reform package number 2 pertaining to the Qualification Directive, the Procedures Directive, and the Reception Conditions Directive. These three instruments are going to be modified or changed in different ways. The Qualification Directive and the Asylum Procedures Directive will be, according to the proposals, will be transformed into regulations, which under EU law means that they will be directly applicable in domestic member states' legal system, and therefore, in principle at least, not requiring transposition into domestic law, which is a fundamental difference, at least in theory, between directives and regulations. For reasons I can't really understand, the Reception Conditions Directive will still be a directive, so for that one there is only a proposal for yet another recast. As you may recall, the Procedures Directive and the Reception Conditions Directive were actually recasts, or the recast directives were adopted as recently as June 2013, only 3 years ago, and only recently had to be transposed into domestic law. So it's a quite quick step, one might say. From the first to the second generation, with a period of more than 10 years actually elapsed, while we now have only 3 years since the second generation and until the proposals for the third generation instruments. If we look in broad terms on the substance of these proposals, I think they can be summarized in the 3 bullet points I have indicated here. There is a very strong focus on sanctions against secondary movements. That's also influencing the Dublin regulation proposal, and it has really sort of become very clear, also clearly reflected in both the Qualification Directive and the Procedures Directive and the Reception Conditions Directive. There'll be, I mean, not criminal sanctions. Those are in place probably already in some member states. But there will be various sort of rights standards, sanctions linked to secondary movements in terms of postponing the possibility for lawful secondary movement under the terms of the Permanent Residence Directive, and conditioning certain standards of treatment under the Qualification Directive also on staying lawfully within the country in which you have been granted protection. The second general feature is, in particular in the Asylum Procedures Directive, to restrict the rules relating to situations of perceived abuse of the asylum system, strengthening, in particular, the treatment of repetitive applications or subsequent applications, and also sort of reinforcing possibilities for declaring certain applications inadmissible, which has to be seen in connection with the safe third country policy. These decisions will actually, apparently, according to the proposal, be sort of moved up front to the Dublin stage of the decision making, which may have a certain sort of bureaucratic logic, but on the other hand, it's also complicating Dublin to a degree which may seem to run counter to the underlying purpose of Dublin. I'll leave that again to Vigdis. And finally, not least, the proposed Asylum Procedures Directive will also imply harmonized rules on safe countries, both safe third countries, including the so-called first country of asylum notion, and also safe countries of origin. There will be harmonization in two manners, one could say. There will be mandatory usage of these concepts, and secondly, there will be, according to the proposal, over time there will be common or joint EU lists of safe countries, which was attempted previously, then given up for a mix of legal and policy reasons, and then already was introduced partly in a proposal on the Asylum Procedures Directive a year ago, and now it's going to be sort of to be done in a more comprehensive way in the proposed procedures regulation. This all leaves us with the dilemma, I think: is this going to deal with protection, or is it merely restriction? We'll discuss that, I hope, in the panel afterwards. But I think there is a risk, whether you're a believer of the common European asylum system or not, there is a risk that member states will far more readily agree on restrictive measures than on the protective ones. There are certain elements of these reform packages which are certainly restrictive in themselves. On the other hand, I wouldn't exclude that stronger harmonization could actually also have some protective benefits, because we still have these vast disparities among recognition rates in various member states. But we have seen throughout the history, I would say, of the common European asylum system, that member states more readily agree on restrictive measures than on the extended protection. So that I think there is a quite genuine risk that this may be going to happen again. There is one promising thing, though. If you compare to the 6th of April communication, the Commission has not followed up on its proposal to increase differences between refugee status and subsidiary protection status entitlements, which was actually an idea expressed in the communication in April, which would run entirely counter to what was the idea of the recast Qualification Directive from 2011. Fortunately, that has been met with so much resistance that they have given it up, which I think is fairly fortunate, both for legal and policy reasons. Thank you.
As Jens was saying, in May 2016, so this year, a proposal for a recast of the present Dublin 3 regulation was launched. and the ambition being, I quote, to establish a sustainable and fair system for determining the member state responsible for examining asylum applications. This is wording from the EU Commission's proposal. Now the question is, can we truly believe that Dublin 4 is going to be much better than Dublin 3? The situation now is that the EU Commission and other agencies and researchers admit that there are significant structural weaknesses and shortcomings in the design, and also, perhaps most importantly, in the implementation of both the Common European Asylum System and also in the Dublin Rules in particular. So what are the Dublin Rules? And what is wrong? And what will be the proposal? Will the proposal be able to amend the flaws? Now, the Dublin Rules are that they designate the responsible state to examine an asylum application. It provides the criteria, and it also provides the rules and mechanisms on how to do it. And this is done, the objective of this is, of course, to ensure quick access to an asylum procedure and examination of the substance. This is an aim for the Dublin Corporation. And this is to be done by one single state. Now, therefore, it is also an ambition, of course, to avoid refugee in orbit situations. One of the worrying sides why we are seeing more use of the safe third country concept again, where we do not have the at least safeguards that are provided by the Dublin regulation. But what is wrong? Now, the list is quite long, and it also, I would say, depends on who we are asking, whether it is the states or it is the asylum seekers. But let us start by looking at 2015. And what we see is a limited number of member states having to deal with the majority of the applications, as also Jens was referring to. And therefore, of course, putting the capacities of certain states into difficulty, under strain. Also, we have seen disregard of EU rules, and we saw, for example, the lack of registration for the Eurodac in accordance with the Eurodac regulation upon arrival, and the secondary movements on a large scale. Now, the criteria contained in the Dublin 3 regulation do not take into account the capacity of member states. Nevertheless, it is an ambition to be effective, and then one can already question the fact that it takes up to 1 year, 10, 11 months, just for the asylum, just for the Dublin procedures to take place, and then the actual examination of the cases will start afterwards. So what do applicants do? They try to avoid being part of the Dublin system. They abscond. And how do member states react? By using, increasing, making use of detention. Now, a fundamental reason for trying to avoid Dublin is the fact that the rules under the Common European Asylum System, as also Jens has been talking about, do not function in the same way in all the member states. This is a very fair reason, I would say, for people trying to move on to a place if you know that you have a much greater chance of being recognized as a refugee in another country, or if you know the reception conditions are much better in another country, or the asylum procedures are better. It makes a fair good reason for trying to move somewhere else. Now, the evaluations that have been done also on Dublin 3 so far, and I have to tell you, I participated in a UNHCR study with 9 countries looking into how it is functioning in practice. It should have been out already a long time ago, but that study is still not published, so I cannot refer to it specifically. But also the EU Commission has made evaluations of the functioning of the Dublin 3. So what they see is that in spite of responsibility being accepted by a member state, transfers are being limited. in 2014, the numbers of transfers of accepted requests was 1/4 of the total. Now, the list of problems is long, and still it is referred to by states as, and also by the EU Commission, as the cornerstone of the common European asylum system, which I think gives food for thought when we consider many of the flaws. So the question is, are we going to see fantastic changes when Dublin 4 is adopted? Now, it is a recast. It is in for negotiations, both in the Council and Parliament. But the two reform objectives are efficiency, to increase efficiency, that is, to shorten time limits, which are at present in the Dublin 3 regulation, and I would say under the same heading of efficiency, also to prevent secondary movements, thus including obligations for applicants in case they don't remain in the country of entry, which will be the main rule, and also if there is non-compliance by the applicants. This will have repercussions on the applicants. They will, among other things, lose the right to stay in a reception center. Now, I would imagine that could create a few other problems for the states where they are, but this is in order to deter applicants from doing secondary movement and trying to move on. Now, the second reform objective of Dublin 4 is the solidarity and the introduction, thus, of the responsibility sharing mechanism to be activated immediately in cases where a member state has to deal with the so-called disproportionate numbers of asylum seekers. But what is not being changed in Dublin 4 at all are the criteria under which the assessment is being made on which country should be responsible. Very few changes there. A little bit broader in regard to family link, but in general, it is the same criteria which continues as we have seen them under Dublin 1, the old convention, and we've seen them under Dublin 2, and now Dublin 3, which you have at present. And we're going to continue on Dublin 4. Now, the research that has been taking place shows that member states interpret these criteria in very many different ways, and they are, to a certain extent, in Dublin 3 being, or the possibility of amending the clause are there because of the discretionary clauses. Now, for Dublin 4, the aim is to limit the discretionary clauses. So where we have today the sovereignty clause, we will have more reference in a discretionary clause in regard to family, but it seems that the protection issue which the sovereignty clause today contains will not any longer be available under Dublin 4. And there are other examples of weaknesses. For example, as also, I think you mentioned this also, Jens, in regard to the first country then being responsible to do the assessment on safe third country and also on safe home country, meaning the procedure, as I can understand it, would be even longer and take longer than the Dublin procedure takes today. Also, the human rights test, which is contained in the Dublin 3, is exactly similar in Dublin 4, which refers to deficiencies, which is today the only reason, as it is stated in the Dublin regulation, systemic deficiencies in regard to asylum procedures and reception conditions. And there has been a lot of litigation already in various national courts, and we are seeing that this is an interpretation which is very narrow in regard to how international public law should be interpreted. So, and this has not been clarified or modified. So I would say in conclusion, maybe we are seeing one step forward in regard to the solidarity aspect being part of Dublin 4, but we're also taking a couple of steps back. Thank you.
I sincerely hope that the final paper will be a tad more optimistic.
And moving on from the cornerstone of the common European asylum system over to the outsider of the system, I'm going to discuss an issue that's been repeatedly mentioned today, and it's the safe pathway of refugees to Europe. I know we're discussing the number of refugees and whether it's a crisis or not, but the fact is we have many millions of refugees living in squalor and danger, and whatever we call it, crisis or not, people are dying and the management is insufficient. We have chaos. As Thomas has discussed, and others, while most refugees have fled to neighboring countries, migration and refugee flows to Europe have increased. And as we have heard about today from the speakers, for many of those refugees, the journey means extreme uncertainty, risks, and dangers. Rickety boats, as we saw in the pictures, full of people, men, women, and children drowning in the Mediterranean, escaping violence and poverty. Those are the facts. People are dying, and the EU is not handling it sufficiently. There is not sufficient migration management. And while the EU member states and the other European countries like Norway and Iceland are searching for some responses to the challenges of this pressure, several ideas have been discussed. And one is the need to open up or expand existing legal routes or pathways to protection in Europe. A part of the European Commission proposal to complete the reform of the Common European Asylum System from 13th of July is the establishment of a Union resettlement framework. As most of you know, resettlement is a process for admitting a third country national or stateless person who has been displaced within his own country or to another country and is in need of international protection in another country that can provide this protection in a safe manner. The proposed framework, which is in the form of regulation, is supposed to promote a more coherent approach to resettlement and other forms of humanitarian admission, and to address a significant imbalance in the effort made by the member states. The goal is to establish a unified procedure for resettling refugees in the European Union, as well as an annual EU resettlement plan setting the geographical locations from where the resettlement should take place and the maximum number of persons that will be resettled. To support the member states' resettlement efforts, the Commission will offer €10,000 for each person resettled. In the proposal, it is established that the Commission and Council shall take into account a number of factors when specifying what regions or countries from where resettlement should take place. Third countries' effective cooperation with the Union in the area of migration and asylum is mentioned as an important element which the Commission will base its decision. Such cooperation should, for example, be reflected in third countries' effort to reduce irregular crossing to the Union's borders from its territory, and their cooperation with the Union on readmission and return of third country national or stateless persons irregularly staying in the territory of the member states. Also, according to the proposal, member states shall not resettle third country national or stateless persons who do not meet eligibility criteria or who fall in the scope of an obligatory exclusion ground. The Commission notes that the proposal widens the classical resettlement categories used by the UN Refugee Agency. Nevertheless, third country national or stateless people who meet eligibility criteria are excluded from participating if they have irregularly entered, irregularly stayed in, or attempted to irregularly enter into the territory of the member states during the last 5 years prior to resettlement. So, despite all its merits for providing a common approach to and common standards for safe and legal arrivals of refugees, the current Commission proposals appears to contain a number of issues and uncertainties. These relate firstly in the way in which refugees are selected, and plans to exclude those, as I mentioned, who have regularly entered state in or attempted to regularly enter into member states. Secondly, the uncertainties relate to the countries from where the refugees will be resettled from, bearing in mind that the Commission proposal suggests the third countries that cooperate with the EU border control will be prioritized. This conditional nature of the proposal has been criticized as a tool to control migration and affect the right to asylum rather than support refugees. Vulnerable refugees should not pay for the political relationship between the third country and the EU. Resettlement should be provided where the need is greatest and not made conditional on the government on the country that hosts them. As Jens went into, some find it to be difficult to be optimistic about a scheme that reproduces to such a large extent most of the rules and procedures of the existing EU relocation and resettlement programs, other solutions of the EU. With such, they have been operated with limited success, as we saw before, since 2015. And given how there's been persistent reluctance by most member states to share the burden of the refugee protection, so supported by others, and with the latest projection of the UNHCR, with the number of people in need for resettlement in 2017 be more than 1.2 million worldwide, some do not have high expectations for the effectiveness of this network, of this framework. The draft is likely to be amended by the EU Home Affairs Ministers and the European Parliament, and it will be interesting to see how it will develop. But even if the criticized issues are amended, this is not the only way forward in terms of legal avenues to Europe. As Thomas mentioned and others have mentioned, another way into Europe for asylum seekers and refugees may be through the expansion or more strategic use of our visa systems. That could allow refugees to apply for travel permits from their home countries or third countries outside of Europe to member states where they would then apply for asylum. While the current visa code does make provisions for member states to issue short-stay Schengen visas with limited territorial validity on humanitarian grounds, the provisions contain inconsistencies and lack clarity, and there is no formal procedure on examination of visa applications lodged on humanitarian grounds. The European Commission's proposal for a recast of the visa code in 2014 did not contain any proposed change to the current framework. Indeed, the Commission has been consistently hesitant about laying down an EU humanitarian visa scheme in the visa code, likely concerned about practical challenges and perhaps keen to retain national control over such scheme. The Council seems to support the Commission's approach. On the other hand, the European Parliament has consistently called for the establishment of safe and legal avenues to the European Union. The proposed updates, the Libe Committee has proposed updates that would allow EU consulates and embassies around the world to issue humanitarian visas to people seeking international protection, thereby dissuading them from trying to reach Europe by other means. Talks between Parliament, Council and Commission began earlier this year, with the humanitarian visa question likely to prove very challenging. Humanitarian visas could benefit both asylum seekers and member states. As Thomas talked about a little bit before, it could ensure the legal, safe and controlled travel to Europe, so refugees would therefore not have to depend on smugglers nor risk their lives to seek protection. Humanitarian visas could perhaps also alleviate some of the pressure on ordinary asylum procedures and possibly lead to a more equal distribution of asylum seekers amongst the member states. One study even showed that, or believed that since we have the option of granting humanitarian visa, we have the obligation to do so because of our human rights obligations. And we need not be afraid. Experiences from designed and operating humanitarian visa schemes in Europe seem to prove that humanitarian visas can be managed both in quality and quantity. The fears of massive increase in the number of cases seems to be unfounded. So, in conclusion, European countries and officials seem to agree that there is a need for opening up or expanding legal pathways to protection in Europe. And this is not only Europe. Like the Prime Minister mentioned before, on 19th of September, world leaders adopted the New York Declaration for Refugees and Migrants at the UN General Assembly, and thereby declaring a political will to protect refugees and provide safe passage. This could save lives and reduce chaos, the alternative measure, the legal ways into Europe. The Union Resettlement Framework could be a way to provide this, but there have been some serious comments made about the tone of the framework, possibly focusing more on migration control than protecting refugees. There are also worries about how successful the framework will be, and whether the states will be reluctant in participating with the need being so great. Alongside resettlement and as a complement to resettlement programs and the common European asylum systems, humanitarian visas could be a real alternative. And just to close by, the happening now is a humanitarian crisis that needs an immediate and concerted European response. And the response needs to be quick, needs to be successful, and need to be with emphasis on protecting refugees. And meanwhile, we run around trying to decide what we do, and people are risking their lives in search for protection, and we have a survival of the fittest access to Europe. Thank you.
Three very, very engaging papers. I see already we're getting questions. So there's one over there. And while you're waiting to get your mic, I just want to ask you, Jens, you mentioned the avenue of litigation, both in a positive way and also in a negative because of unintended consequences of secondary movements as a result of particular cases. Do you think we should be emphasizing even more litigation as a strategy in changing approaches to protection?
Given that I'm working with teaching human rights law, I can only favor human rights litigation. But more seriously, I think that all independent human rights lawyers, whether they are teaching, researching, working as practicing lawyers, I mean, everyone was probably happy on the 21st of January 2011 when at long last the European Court of Human Rights realized the collapse of the Greek asylum system, because there had been previous decisions which were sort of reflecting sort of willful blindness on the part of the European Court of Human Rights. So in that sense, I would say yes, it was the way forward because it was about saving human suffering simply. On the other hand, upon reflection, I think I can't avoid or prevent thinking that the outcome has had some, as I termed it, some problematic incentive implications, both for certain member states and also for asylum seekers, of course, all of which is very understandable and again, of course, calls for the common solutions because it could be remedied, but it wasn't. And therefore, it was an even stronger and more visible collapse in Greece during 2014-15.
Thank you. Okay. First question, please identify who you are.
Thank you. My name is Catherine de Coster. I'm working as a Schengen coordinator for the Norwegian Immigration Directorate. I just want to comment on the last speaker because I participate also in the Visa Working Party for many years. I think it's very understandable that you are looking for solution, but being also a lawyer, I want to say that sometimes one doesn't look at all the consequences. When it comes to this humanitarian visa, you have to recall that the Schengen Acquis and the Visa Code, the Schengen Convention, is made for short stay. That means it's supposed the return of the person who has come for a visit. The special VLTV, visa with limited travel validity, may be used in some very special case, also for people who will return but don't have the time to wait for a visa. Because there is, for example, a burial within 48 hours. But there is only one country not opposing, so it's not just that the Commission opposed clearly, but it is a very red line for all other member states. And that has been stated very, very clearly. So I don't think this is the proper instrument to address the crisis. Then I want to add, because there are things that sometimes people don't know about the reality on the field. As, when you ask for a visa today, you don't go to the embassy or the consulate, you go to an external service provider. To imagine these people having to face external service providers? This is the reality. And then have you ever thought about the problem when people will apply for protection in our embassies which don't have the capacity to address these issues, the competences, how it will put our embassies in a situation towards the country where they are guests. That could be also extremely problematic. So yes, there may be other legal instruments, but I don't think you will find them directly in the Schengen Acquis.
Comment?
Yeah, go ahead.
Thank you so much. So you have very valid points, and actually those are the points that the Commission is making. They're focusing on this is for a short stay. This is not for people coming to stay for a long time. But that's what we are. How we are trying to be creative. How can we use the system we have to kind of diffuse the chaos, to diffuse the situation. And this is one way. It would need changes. The legal environment right now is uncertain and doesn't complement this idea very well. But how could you change it? Would this be a viable option? And many believe it is. That this is a way that could possibly alleviate pressures on the asylum procedures and could help refugees. So, and we need to examine all creative ways we can use, because what we have been doing hasn't been working that well. And as many have said, the chaos is not helping, and this would provide a safe and controlled entry into Europe. So it's at least very worth looking at how we could change the visa code, perhaps in some way, like the parliamentarians, European Parliament has suggested, proposed. And I know Thomas has strong opinions on this, so maybe his microphone should go directly to him.
Is it directly on point to this? Yes.
Yeah.
Okay. Then Thomas, can I answer directly, and then we'll go back.
My name is Ali, and I'm from Stockholm University.
Yeah.
I think we
go ahead.
I think we're dancing around some issues, or the elephant in the room. If you are really interested to stem the flow of refugees, then it is crucial to recognize that most of them come from failed states. And the phenomena is a result of international politics and the global economic system. We are very much interested in, or concerned with, how much tolerance we can afford without adversely affecting the Nordic countries' lifestyle and values, instead of dealing with the crucial issues, the failed states. That's where most refugees come from. And we're looking inwards. How do we deal with refugees in terms of numbers without them affecting our lifestyles? That is the issue here. And that's the elephant in the room. Mm-hmm. How much refugees we can take without affecting our. And that affects the discursive practices of migration politics, both at the national and the supranational levels.
Yeah, thank you. Well, the elephant has been addressed here today, at least. And it's true that there has been an elephant for a long time, and the Prime Minister mentioned this point for herself today, that they were trying to conserve also the Nordic countries, but you raise a very valid point. We need to look at this holistically, not just in tight corners. Do you want to add with this? Or?
Thank you. Just a comment on this issue of protected entry procedures. I think there are plenty of case studies in Europe that have shown that humanitarian visas can be quite effective if we're talking about targeted mechanisms of bringing bona fide refugees out of countries. I mean, we've got plenty of examples also from the Nordic countries. I mean, Denmark did something akin to this in regard to Iraqi interpreters. Similarly, there's also been practical experiences. Again, Denmark used to operate an embassy asylum procedure, but of course there has to be some kind of limiting mechanism in terms of applicability. In Denmark's case, it was affinity to the country, but you can imagine something like that being rolled out on a European scale as well. And it goes without saying that such a system could never operate inside countries of origin. I mean, for the lawyers in the room, I think that there's an older case from the European Court on WM versus Denmark concerning Eastern Germany, with the kind of problems that might emerge from exactly such a situation. But while I have the microphone, I wonder if I can ask a short question to the panel.
Yes.
I was wondering, because we've now been talking about these different dimensions and the sort of struggle between trying to do reforms and not quite getting there. There seems to be some similarity in the kind of skepticism in terms of whether the proposed reforms will actually work in addressing these underlying issues. I can't help but wondering sort of if we could move and get some reflections on the larger political context here. And I want to partly cite a new article by Thomas Spijkerboer, Martin Den Heijer, and Jorrit Reitmer, sitting right here, from Common Market Law Review, which is also talking about these sort of structural challenges underlying the European asylum system, which relates to the sort of kickback against more coercive measures being taken in terms of forcing the hands of member states. So if we recognize that part of this issue of the sort of collapse from within of both Schengen, Dublin, etc., has to do with deeper-seated political resistance against supranational regulation, is it politically tone-deaf of the European Commission to propose strengthening EU regulation? I mean, is the answer to that problem really stronger and more directly binding EU law on the matter? And B, having stronger institutions? I mean, it's an open question. I can see how that might work from sort of the lovely perspective of us being sort of engaged in these debates in a more technical sense, but I just needed to bring that political element into it.
Yeah. Could I address the elephant first?
Yeah.
I just want to say one word on the elephant, and that is, I think it's important to keep in mind what we're actually discussing. We're talking about people fleeing from persecution, from war, from violations of human rights. We have an obligation to give protection. I think we cannot start by identifying numbers, how many are they, nor can we start off by saying, does this mean that I will be able to go to the cinema one time less in a month because my welfare is going to be reduced because we are undertaking the obligations that we have undertaken? I had to say that. And I also think it's also a question of the long-term and short-term responses. We also need to not give too much focus only on the difficulties, but I think we need to be creative in solutions. So I second very much what Erna was saying to that effect. Now, what do the member states want? What do we want? I have to say, from my perspective, being an optimist, otherwise you cannot work in the field of international law, I think. I believe that it is possible to make a common European asylum system better. But I think a lot of work needs to be done on it. And those who are actually the decision makers need to lend their ears to, among others, lawyers who actually know something about the norms that we are that we have an obligation to abide by, and to see how human rights norms also go together as a system. It is not just something that you can out of the wild say, let me find a political solution and forget about the norms. That's not how it can be. And I think we are seeing a development which is a little bit dangerous and going in that direction. So there is quite a lot of work that needs to be done. But yes, Thomas, this is going to work. Do you want to add?
Okay, we have a question over there.
Hi, my name is Bård Vegar Solhjell. I'm a Norwegian politician. Maybe the only one here, actually, it looks like. I don't know much about elephants, but just one perspective I'd just like to briefly bring up, because I don't think you can discuss this, at least not in a more political world, without having one very basic fact in the background, and that is that if you go 30 years back in the mid-80s, the parties we called right-wing populist or right-wing radicals, or use different names in Europe, had an average percentage in elections of around 2% in Western Europe altogether. Now they have an average of 15%. And in many countries, 20 to 30. In Germany, a country where right-wing parties have never been in parliament after World War II, they now have almost 20% on the polls. And it's a very, very basic political fact. And they recruit voters mostly on two issues. One is, of course, what we're discussing here, migration, or immigration, rather. But the other is resistance towards the European Union. So it kind of goes together, and that shows the problem. Because I think the solutions that you discussed, that I very much support many of the ideas, but they are only possible if countries want to take more refugees, and if they want to share responsibility, create a more common system. So I think it very much starts with a political discussion and political will, on one hand, but also maybe one perspective that I think you brought it up in your point first. That is, it's also very much an issue of self-interest, because it's in no European country's self-interest to have a system which is chaotic, unstable, with lots of secondary migration and so on. And it's not in our common interest that the Sahel region and the Middle East explodes just around us. So I think also maybe the self-interest perspective can be very important for gaining support among those who are skeptical or critical towards taking many refugees. Thank you.
Yeah. Go ahead. I have a shy panel.
I'm not really in a position to comment much on what the most recent speaker said. I can only agree in principle, but also, as you suggested yourself, link it to Thomas's points this morning. So I would rather actually go back to Thomas's question about the sort of the intensity of EU harmonization. I see the point. We are approaching, of course, a divide corresponding to what Donald Rumsfeld respectlessly termed as old Europe versus new Europe, and I simply fail to comprehend what can be done about that. I think the immediate response is logical. I think to intensify EU harmonization by sort of limiting or taking away, simply abandoning possibilities for member states to mingle around in the transposition process. Still, there will be risks or possibilities of disparities because it all has to be implemented and applied in very concrete decisions. So I don't think we shouldn't expect a full harmonization, and that I think sort of calls for considering the possibility of joint processing. That may also be a kind of elephant, although of an entirely different nature. But I think it is worthwhile considering. It has been sort of mentioned. I think it was sort of it was suggested in the Stockholm program that the Commission at least might want to carry out a study on joint processing, which has been done. But so far, I think we have seen only joint processing as emergency measures in Greek islands and so on. Secondly, I would say that regardless of the level or degree of legal harmonization, I'm afraid that the worst result ever can be if we have legal rules, however binding they are, or whatever strength or level of harmonization they are reflecting, if they're not being enforced. I mean, that is the situation at present, that we have a lot of situations in which member states, in particular in what Rumsfeld termed as New Europe, simply defy binding norms. I mean, now we have sort of these border closures or similar phenomena also in Poland. We have Austria with the quota system. Of course, we have Hungary, and so on. And apparently, the Commission has no political courage to simply pursue it in court. And that is maybe the worst thing of all, to pretend having a normative structure which doesn't work at all.
Yeah. We are out of time, so I think we're going to have to take further questions at lunch. I would like to tie up this panel with the previous one. I like the referencing to the rise of the right politically within Europe. If we recall the first panel, the emphasis on the use of the police, we recently celebrated the anniversary of the Nuremberg tribunals. And we were reviewing the cases against some of the lawyers working for Hitler and some of their inventions, which included preventive detention and deportation. Sound familiar? And we had a representation from a member of the Jewish community in Norway who actually pointed out that during the occupation, the soldiers of the Nazi regime would be sent to arrest the members of the Norwegian resistance. But in terms of arresting the Jews for deportation, they would just send the Norwegian police, because they knew that the Norwegian police regarded the Jews as others, as non-Norwegians, and they would ensure that that deportation would take place. So a re-emphasis on use of police in terms of deportation and preventive detention, it brings about identification with policies with regimes that don't correlate, as was pointed out, with how we identify ourselves as Nordics, or even, I would argue, European. So maybe it's not just about law, but also about engaging ethicists, philosophers, sociologists, and people who study society into ensuring some sort of social reflection at the national and the regional level to ensure that we understand the consequences of the policies we are pursuing. Thank you very much to the panel, and I hope you enjoy your lunch and have a wonderful afternoon.